The Silicon Valley firm Ripple cited the regulatory uncertainty in the United States for skipping XRP on Liquidity Hub. Ripple, the technology company behind XRP, has stated the reason behind its deliberate decision to exclude XRP from the newly launched Liquidity Hub product. The firm has indicated the ambiguous regulatory environment surrounding the asset in the United States as the main cause for this decision. The official Liquidity Hub was recently updated to accommodate this information, as disclosed by Ripple in a follow-up tweet. According to information on the page, Ripple intends to consider XRP for possible inclusion in the Liquidity Hub solution in the future. This addresses community concerns about XRP being completely excluded. Ripple clarified that XRP's inclusion in the product is contingent on the asset's regulatory clarity in the United States. Notably, if the Ripple v. SEC case concludes with a consensus that XRP is not a security, Ripple could incorporate the XRP into the Liquidity Hub product. However, if the judge rules that XRP is a security, it will likely remain excluded from the solution. Recall that Ripple introduced the product in November 2021, noting that it would support XRP and 5 other assets when it eventually launches. The absence of XRP upon the launch of the product raised questions among XRP proponents. Attorney John Deaton weighed in on the recent situation and offered his opinion, drawing parallels to previous cases, to shed light on the rationale behind Ripple's decision. Deaton noted that Daniel Schulman, president and CEO of PayPal, met with Jay Clayton, the then chairman of the US SEC, just before PayPal launched crypto. Deaton pointed out that PayPal conveniently left out XRP in its digital asset offering because it knew the lawsuit was coming. Notably, Robinhood also does not support XRP. Considering these facts, Deaton emphasized that the ongoing SEC litigation has significantly hindered XRP's advancement. While acknowledging the disappointment felt by XRP supporters, given Ripple's close association with the asset, Deaton maintained that the issue is not about Ripple's stance on XRP but rather a matter of the law. Deaton emphasized that Ripple's expenditure of $100 million to prove that XRP is not a security indicates that the firm does not consider XRP a security. However, he noted that the issue is not Ripple's opinion on XRP but rather the law and the risk perception among other American-based companies. Notably, XRP's presence in the Liquidity Hub at this point could discourage US-based businesses from using the product due to concerns about potential sanctions from the SEC or other regulators, given the regulatory uncertainty surrounding the asset. Please, do not forget to subscribe to our channel and also hit that notification bell to be the first person to get more updates about the latest happenings as regards to XRP. Over the past few weeks, there's been a debate about whether Ripple's fair notice defense has merit. On March 3rd, the leading Silicon Valley tech company filed a supplemental letter supporting its fair notice defense in its lawsuit with the Securities and Exchange Commission. The defendant's fair notice defense highlighted several factors why they didn't anticipate an enforcement action from the SEC. The points raised include the lack of clear rules for the crypto market and former SEC Director William Hinman's endorsement of Bitcoin and Ethereum as non-securities. Despite Ripple's argument, some still assert that the leading blockchain company's fair notice defense is without merit. Responding to these critics, crypto law founder attorney John Deaton recently made a Twitter thread explaining why Ripple's fair notice defense is not meritless. According to Deaton, these critics must ignore the facts and the law to claim that Ripple's fair notice defense is meritless. You can argue that it won't ultimately prevail, but it's not meritless, he concluded. Deaton noted that in June 2019, the Securities and Exchange Commission did not reject MoneyGram's partnership with Ripple to utilize the blockchain company's XRP product in foreign exchange settlements. If XRP was itself an illegal security the way the SEC now claims, why would the SEC allow this MoneyGram partnership 18 months before Clayton dropped the lawsuit on his last full day at the SEC and the very next day after meeting with Gary Gensler he quizzed? Following the SEC absurd theory of what is an investment contract, Deaton asserted that MoneyGram's sales of XRP through Coinbase could also be considered an investment contract with Ripple even when purchasers did not know the blockchain firm. Deaton said the SEC did not raise dust about MoneyGram's application to acquire and sell XRP. Instead, the securities regulator advised MoneyGram to record XRP sales as a contra expense. Furthermore, Deaton pointed out that the Financial Stability Oversight Council's annual report, which former SEC Chair Jay Clayton signed, highlighted XRP alongside Bitcoin, Litecoin, and Ethereum. Deaton also mentioned SEC's enforcement lawyer's Howey XRP memo as one of the merits backing Ripple's fair notice defense. Notably, although Hinman did not mention XRP in the controversial June 14, 2018 speech, Deaton asserts that SEC's enforcement lawyers issued a Howey XRP memo a day before. Even though the document is still privileged, Judge Sarah Netburn has disclosed that the SEC officials never made any recommendation at the end of the analysis. If SEC enforcement lawyers had determined that XRP was clearly a security, they would have recommended action be taken, Deaton said. He added if the lawyers had found that XRP was a security, they would have recommended that a cease and desist letter be issued to Ripple. Only when the company refuses to adhere to this notice will enforcement action be taken against it, Deaton asserts. Moreover, Ripple's CEO Brad Garlinghouse and CTO David Schwartz met with the SEC around August 2018 to discuss why Hinman never mentioned XRP in the controversial speech. Had the memo found XRP clearly as a security, they could have handed it to the CEO and CTO of Ripple and said, "Here, read this." But they didn't. Instead, Clayton said, "Okay, just keep talking to the staff about it at future meetings," or words to that effect, Deaton said. Another point backing the merits of Ripple's fair notice defense is the ethics disclosure filed with the SEC by a market participant Ballard Incorporated on January 1, 2020. In the filing, Ballard informed the SEC that it should not worry about its cryptocurrency investments because it will only deal with the three top crypto assets BTC, Ethereum, and XRP, generally accepted as currencies and not subject to the SEC's regulation. Deaton, who represents thousands of XRP holders as amicus curiae in the lawsuit, pointed out that the SEC also informed the public 60 days before charging Ripple that it has never determined the cryptocurrency as a security. Now to our main focus for the day: will XRP be integrated? Please do not forget to subscribe to our channel and also hit that notification bell to be the first person to get more updates about the latest happenings as regards to XRP. Stuart Aldarity, Ripple's general counsel, has shared an exciting update about the SEC's legal woes at the Supreme Court of the United States. In a tweet yesterday, Aldarity noted that the Securities and Exchange Commission had lost 5 out of its 6 cases in the country's apex court. The regulator's latest defeat came from the SEC versus Cochran case yesterday. The lawsuit questions whether federal district courts can concurrently hear constitutional challenges to the SEC's administrative law judges in cases where the regulator has not issued a final adjudicative order. Interestingly, the case was ruled in favor of Michelle Cochran, a certified public accountant whom the SEC alleged failure to comply with federal auditing standards. It is noteworthy that Aldarity has been keeping track of SEC's defeats in the Supreme Court. In February, Aldarity reported the agency's 4th loss in the apex court. He applauded the few entities that have gotten both the courage and resources to challenge the SEC's adverse enforcement actions. The SEC's recent defeat at the apex court also prompted reactions from members of the XRP community, including crypto law founder attorney John Deaton. According to Deaton, the SEC has continued to lose credibility with each case. He referred to how the SEC's administrative judge bullied the defendant in the SEC v. Cochran case. Furthermore, Deaton cited a critical point in the lawsuit, which reveals that the SEC wins 90% of cases in in-house proceedings compared to the 69% success-rated records in cases brought in federal courts. The SEC's defeat at the SCOTUS is imperative in the ongoing Ripple lawsuit. For context, Ripple has declared its willingness to pursue justice to any length, including taking the case to the apex court if Judge Annalisa Torres does not favor it. Attorney Deaton reiterated that Ripple's arguments best suit the Second Circuit and the Supreme Court. Notably, Judge Annalisa Torres has yet to rule on the case. However, if the court does not rule in Ripple's favor, Aldarity said the company would immediately file an appeal. Given the SEC's legal woes at the Supreme Court, there is a tendency that Ripple might win in the apex court if the lawsuit gets to that level. So we come to the end of this video, guys. If you enjoyed it, please make sure you like the video. Don't forget to subscribe and hit the notification bell. This really helps me with the YouTube algorithm. Also, you can help enlighten